assault, the fear of putting somebody, it's putting somebody in fear of getting hurt, coupled with the capability of doing so. Battery is when it results in any unwanted contact. False imprisonment is completely taking away the freedom of a person without any legal justification. We will see examples on that, but understand, for false imprisonment, there are two conditions necessary. One, the complete independence of the person, the complete freedom of the person must be restricted. So if I prevent you from entering your house, but you are free to go elsewhere, you cannot accuse me of false imprisonment. But if I keep you in a room and lock the room from outside and don't allow you to go anywhere, that is the first condition of false imprisonment which has been met. But more importantly, I must not have a legal excuse or justification for taking away your independence, your freedom to move. If a policeman under suspicion takes you and puts you in a lockup, later on, even if it is proven that you are not guilty, you cannot sue the policeman for false imprisonment, because at that time he had reasonable suspicions, and moreover he is justified in keeping you in detention for a short period of time, or as far as the charges are not clear. So two conditions for false imprisonment: A, total restriction of your liberty, and 2, no legal justification or no legal excuse for having done it. And negligence we have already seen. For property, you can be protected from nuisance. Somebody nearby keeps throwing garbage in your house or keeps watering his plants, which also splashes and muddies up your house or something like that. Could be trespass to your land, your goods, or chattels. Chattels are basically property owned by you. Once upon a time, the term chattel was also applicable to the wife, no longer so. Or any damage which was done as a result of negligence. Now, economic interests are something which are protected, but they are limited in nature. And more importantly, you have to distinguish whether the economic loss was as a result of a lawful business practice or an unlawful business practice. Like we have seen Daniel Sunday injuria, you might actually suffer an economic loss, but that does not mean that you have the right to go to the courts, because you can go to the courts only if some law has been violated. So if you are suffering a loss because of a legitimate business practice, nothing can be done. It's only your losses under illegitimate or illegal business practices which can be covered under torts. And any economic loss is not restituted or compensated for in the complete amount. In fact, there is an extent of liability for negligence which is circumstantial. So let us take an example where I say A is driving an excavator, a digging machine, and he negligently, carelessly cuts an electricity cable which leads to a factory. Now, the factory is forced to close down for a day and the production is lost as a result. To give you some numbers for this, let us say that the factory produces X number of goods every hour. So they start at 10 to 11, a batch is completed. At 11, the batch is removed. Machine is loaded with the raw material set. 11 to 12, the machine runs. 12 o'clock, when the machine stops, second batch is ready, and so on. From 10 to 6, they completely run these things. During the production of goods, the machine has to run for the entire hour. Any time in between, if it is stopped, the raw material loaded gets spoiled, cannot be reused, and even if the machine is restarted, they cannot continue. That batch has to be discarded. Now let us say on the day of the accident, the factory started as usual at 10 in the morning, 10 to 11, first batch completely fine, 11 o'clock, second batch raw material loaded, 11:15, the cable is cut. The machine stops, production comes to a halt. And as luck would have it, they are not able to restore the electricity before 7 in the evening. That means the entire day's production from 11 till 6 could not be carried out. Now, we all are pretty sure that the driver who negligently cut the electricity cable is liable. No doubts about that. But the point here is, for how much is he liable? What is the extent to which he is liable to pay the damages to the factory owner? So here are the same basic facts which I gave, and let us take a look at the solution to this. Any production which has been started at the time of the interruption of the supply and is damaged will be classed as the damage to property and can be claimed. So at 11, whatever raw material you loaded, at 11:15, because the electricity was cut, the production was stopped, the raw materials were destroyed, that particular batch of raw material was wasted, that is a loss you can claim. However, from 12 till the end of the shift, there was no production, but there was no economic loss as such, because the machine was not loaded with any new raw material. The raw material could have been loaded the next day and used for batches. So although you could not manufacture the goods, you only lost your profits. You did not lose any raw material post 12 o'clock. The only actual economic loss which you suffered was the raw material which you lost, which were on the machine at the time of the electricity being cut. Now, some of us might be tempted to think that if the electricity were not cut, then obviously production would have occurred from 12 to 6 or 12 to end of day. So what about the profits which were lost for that particular day? Well, the law or other common sense dictates that there is no guarantee that from 12 to 6 there would have been a production. Normally, yes, they produce for the entire day. But what if at 12 there was an earthquake? What if at 12 riots broke out in the city? What if at 12 all the workers decided to go on strike? You cannot in any way prove that there would have been guaranteed production from 12 to 6. The only proof of loss is the raw material which got spoiled from 11 to 12 because it was loaded in the machine stopped mid-production and it cannot be continued. So the only amount which the driver would have to pay is the loss suffered from 11 to 12, and that is the amount of the raw material which is there on the machine. Now, do you think this distinction makes sense? Well, if you are the owner of the factory, then you will say, obviously, I have lost so much of profits, I do not agree to such a thing. But if you are the driver, then you can, this actually makes sense, because you are directly responsible to an X amount of provable loss, and that is the only thing which you will be expected to pay. Now, when we talk about strict liability, there is no necessity to prove the intention, the guilt. But in a lot of other cases, your act or your actus reus is not enough. Mens rea, or the intention, is extremely essential. So in tort, fault could mean either malice, intention, or negligence. And remember, as we have mentioned before, if the intention need not be proven, if the very act itself is enough, then it is known as a strict liability tort. So, let us say A was operated on by surgeon B, something went wrong during the operation, A is incapable of looking after himself. Now, if A sues B for negligence, and if the action is successful, then A will be awarded £500,000 as damages. The question here is, was B negligent or at fault? And in case you are about to give me an answer in yes or no, stop. You do not have the facts. Because in this case, it is extremely essential to understand what was the intention of B, or rather, what was the state of mind that B was under. If B was a competent doctor, a competent surgeon, he took every possible precaution, and despite of all the care, something just went wrong, you cannot hold him negligent. However, if B purposely did something wrong because he had some sort of a grudge against it, or if B did not exercise the amount of care that ordinarily a person in his place should have, or if B was intoxicated at the time of performing the surgery, or whatever, then and only then negligence will be proven and B will be held liable. So in this case, you cannot give a judgment unless and until you know what was the state of mind or what was the intention of B, or whether there was an intention or whether there was negligence or whatever. So malice, intention or negligence is necessary for those which are not strict liability torts. Malice is the intentional doing of a wrongful act without a proper excuse. I want to hurt you because I have got some sort of grudge against you. I wish to see some sort of damage occurring to you or your property. That, because that's an evil intention in my mind, amounts to malice. But if the person is doing something right, something which is not illegal, then even if malice is present, does not matter, because the act by itself is not illegal. So an illegal act coupled with the wrongful intention of malice can amount to liability. Intention is necessary in certain cases where trespass, fraud, injurious falsehood, conspiracy, etc. are involved. Because you cannot trespass unintentionally and be held liable for it. You cannot commit fraud unless you have the intention to do so. And the word conspiracy itself explains how intention has to be present. Negligence is careless behavior. If you are supposed to take certain amount of care and you did not, you better be accountable for it. Now, what is the basic objective of any tort? Tort or tort laws basically exist to either serve as a deterrent or to provide compensation. How does it provide deterrence? Well, the individual who is punished once he gets caught and convicted will obviously think twice before trying to do the same wrongful act again. And the punishment given to the individual will also serve as an example to the public at large. So if I am convicted of something, I am punished for something, looking at me, looking at my example, you might think twice before committing that wrongful act. So these laws serve as deterrents. And obviously, for compensation, if I am caught for a wrongful act, if I am convicted, and if I am asked to pay you some amount of compensation, then you have in some amount got back either what you have lost or a monetary equivalent of the same. So, as we have seen, torts is not something which is bound in books. Tort is not something which is based upon certain arcane, old, ununderstandable principles. These are small things which occur on a day-to-day basis. It could be things for which are a nuisance, which are of negligence, anything which cannot be written down in law but which is understood by the general public can fall under this category. So tort is all about twisted behavior. When you face any question in legal aptitude from this section, all you need to do is use your common sense. Think how a reasonable person would be expected to think and then try to judge. Finally, a lot of different examples are present. If you take a look at all these examples, you will quickly get an idea of how to interpret the basic principle which is given to you and how to select the right judgment from the given options. So this was a basic session on torts, a part of legal aptitude. My name is N. Satyanarayan. I wish you all the very best. Have a good day.